It's great distance. We're not.
All right, it is 4 p.m. and we will call the Committee on Public Safety to order. Please note for the record that all committee members are present. If I could have a motion for the May 13th minutes. All right, we have a proper motion. All those in favor say aye. Aye. All right, motion passes. Next, we are on to public comment. Do we have any member of the public? Do not see anyone else present that would like to make a comment. I do want to note for the record that we have had some email communication regarding agenda items 5B, C, and D, I believe, B and C. We have an email from Mitch and Candy Rice in support of the proposed resolutions. We have an email from Kathy Toby, not in favor of the proposed resolutions, as well as an email from Joe Vitale, who is also not in favor of the proposed resolutions. And those communications will be part of our official record. Moving on to item 5B for discussion and action. We have the resolution to introduce and set a public hearing, amended chapter 1460, section 1460.49A to require that rental dwellings have insurance covering tenant relocation costs.
Yeah, I would move to untable.
Thank you.
Yep.
Proper motion has been made. All those in favor say aye.
Aye.
Okay, this is untabled. I do not see anyone here from ED&P today. I know Mr. Van Fossen is out of the office, so no input from that department. Do we have committee members who would like to make any comments or ask question of legal or?
So if you could, Lisa, go through the changes for us just to, so everybody's on the same page.
Absolutely. So we have added the provision that the owner or their agent has provided proof of a valid insurance policy. We've added the phrase carried by the owner or the tenant to clarify that this can be essentially renter's insurance held by the tenant that provides coverage for tenant relocation. But what we did do to kind of clear up some of the confusion from last time is that we added, starting at line 16, the sentence that at the time of application, if the owner does not have proof of such insurance, the certificate of compliance may still be issued so long as they sign a written acknowledgement of the requirements of the tenant relocation section that, you know, we're proposing to add. We would still need to initiate a court action to recoup these costs under that framework, but we would at least have a written acknowledgement that the owner is aware of this cost and agrees with it on the front end. So a couple of things. The changes are intended to clarify that the insurance can be held by the owner or the tenant, or in the event that the owner does not have, you know, a tenant ready to go at the time they're ready to issue or give the certificate of compliance, there is an avenue for them to get a rental certificate without having that insurance.
So it does not require, just to be clear, it's not going to force landlords to buy this insurance if they understand that they will be on the hook for the second part of this.
Yep.
And it doesn't force tenants or landlords to force tenants to buy renters insurance before they move in, correct?
Obviously, we can't require that a tenant carry renter's insurance. I know that was a question that was come up. So to answer your questions, I guess more directly, no, it does not require that the insurance be purchased. It does require a signed acknowledgement that the landlord is aware of the requirements of the tenant relocation. And then between the landlord and the tenant, whatever that contractual agreement is, if there's a provision in the lease that requires tenant to carry renter's insurance, that is a separate private issue that the city is not involved in.
Okay. I think that was, some of the concern is if they're required to get this insurance, they would have to increase the rent price. And this gives, I think, good landlords who have not had a record of this issue, the way to get out because, they don't have to get this rider. And we already know that those folks will step forward if something were to happen catastrophic to their rental and take care of the individuals that are living there.
If I may also.
Yes.
I know that there was some question last time we had a meeting about the line in, beginning at line 14, about the violation of this code shall not prevent the issuance of a certificate. We've proposed striking that out. So that is intended to clarify that an inspection occurs, property taxes are paid, this written acknowledgement, or the insurance is provided. And those things all need to happen before a certificate will be issued. So that was hopefully intended to clear up some of the confusion I think we identified at the last meeting. That was the other change from draft 1 to draft 2 in front of you now.
I do have one quick question because you did answer and reiterated a statement that Greg Bunker had told me briefly just before this meeting that we cannot enforce that renters carry renters insurance through the city of Lansing. Is a private landlord, it was my understanding that landlords can suggest that renters carry renter insurance. Do you know if landlords may make that an obligation of their renters? Is that legal if it's a private a lease agreement is a private agreement out of our purview?
Yeah, I would have to check into that a little bit in terms of what a private landlord and an individual, but generally, two individuals can contract for whatever they deem appropriate, so long as appropriate consideration is given. So there is a little more freedom or leeway, I guess, in the sense of, the requirements of a lease, things like that, that the city's just not privy to.
Sure. And then I have one additional question. Beginning on line 19, 2 copies of the certificate shall be issued within 30 days, so on and so forth. At line 22, 1 copy of their certificate shall be prominently displayed in the front entrance area of the rental dwelling and dwellings containing 1 or more rental units. And that's my question. If you are a property owner renting a single family home, does that mean that the certificate must be displayed within that home or outside the property? Can you
No.
clarify that?
Sure, absolutely. So this provision requires that the rental certificate be displayed sort of in the communal area of a multi-unit dwelling. If it's a single family, it's not required to be displayed. Obviously, they're required to have the certificate, but it doesn't have to be like framed.
Prominently
And-
displayed.
yeah.
Okay, that was my question. I just didn't know how that piece would work, or for a duplex where there is no communal area necessarily, how that would, if it's a requirement that it be displayed, how would that need to be displayed?
Reads to me like it should be any rental.
Yeah, I guess when I read that before, because I asked myself that same question. So if it's when any of the rental unit is vacant, then they have to display the certificate. That's the provision of that sentence so if everything is occupied, then there's not a prominent place that is required to be displayed. But when 1 or more of the units is vacant is when that display, so that it's intended.
Okay, I see.
To when people are showing rental properties.
That's understood
It
by the
is.
prospective tenants. They can see that.
That is the
Thank you. And that question didn't necessarily touch the heart of the purpose of this, but it was a question that I had after reading this through.
So I would actually delve further. I think that we should have a discussion in this committee as well with EDP. I've had this discussion with numerous folks where we're having some kind of a sticker on the front main entryway of these rental properties that is saying this has been certified. like you would with a tab on your vehicle.
I'm sorry to interrupt. If you look on page 2, beginning at line 3, any rental property with 3 or more rental units must prominently display the certificate in the front entrance area of the rental dwelling. That's already a requirement.
Sure. And I think I'm more referring towards if someone's looking at a single family home, when you walk up to the front door, you should be able to see some kind of a sticker that's in the same spot that says, you know, this, we can red tag things and say this is unsafe, but we should be having some kind of a tag that says this is safe, it was inspected. If it's not in here, maybe that's a bigger conversation with code. I'm kind of veering off. The other thing is you had mentioned the requirement for renters insurance. I'm familiar with several landlords' applications that they do require the tenant to get renters insurance.
Okay.
But again, that's I think probably a private matter
Mhm.
of whatever is in the lease agreement. I know other municipalities do things like East Lansing has the owner and the renter sign an agreement of who is taking care of the lawn and the snow, and then that is submitted to the city. So if there's an issue with the snow or the lawn, they know who is supposed to be taking care of it.
Yeah, it's also my understanding that in East Lansing, in order to obtain a rental property, you have to have the buy-in of the neighborhood. Like the neighbors actually have to, certify that they're okay with that home or building becoming a rental property.
There's actually whole neighborhoods. The one that's adjacent to where I live, just over the border on the east side, is literally a no rental zone. And they've got maps of it. They have 3 exclusionary zones, which is a bigger conversation of
Sure.
exclusionary zoning. Sorry, again, veered off. I think the way that this is written, I think that it protects, the 2 folks that had mentioned concerns. I think it does take a lot of those concerns down. Because if, they're, again, good landlords, and I know Kathy is certainly a good landlord.
Right.
She certainly can just agree to know that there's section 1460.51 and it will never cost her any more money because we know she's going to do the right thing. And I think that's going to be true of 95% of folks that are landlords in this city. This is, a direct result of years of work, I think, to address what happens when notoriously bad landlords have really bad things happen in these houses and folks have nowhere to go. And we have no way to twist the landlord's arm. And this gives us, I think, another tool in the toolbox. And I like to always keep putting tools when we can in that toolbox. So.
I do have one additional question for Law, unless you had more questions or comments.
No, I guess my only thing, Lisa, in terms of in practice, maybe I'm just not understanding this. So if the landlord is able to meet the provisions of this by way of the tenant, right, at the time of actual issuance of the certificate by way of the tenant having renter's insurance, but then in that 3, it's a single family home, right? And within that 3-year window, that person moves out, somebody else moves in. What happens? That person doesn't have renter's insurance.
So
They have to sign the acknowledgement. They don't have the rider, but now they have a tenant in there with.
then we would fall under the requirements of 0.51. So 0.51 will apply anytime there's not a valid
Okay.
insurance policy that covers this relocation cost, whether it be through the landlord or the tenant. And that's intended to kind of protect against that situation where there's valid insurance at the
I
time.
just wanted to make sure, and I get that that's a requirement regardless, but I just wanted to make sure that this doesn't weaken our position in court where this written acknowledgement piece, right? So if it is a court action and we actually go to court, and well, I never signed an acknowledgement. You know what I mean? Just because that's in black and white.
I think part of that is going to be kind of how we operationalize it, but kind of the way that Mr. Venker and I envisioned it when we were kind of drafting this change is that it's a portion of the application for a rental certificate, no matter what.
Okay.
But that it's there so that we can point to that. And then obviously we have the requirements of 0.51 that we can kind of lean on, if we do need to pursue a court action.
So now I have question, because that's tipped my thought process. Instead of having this, the wording of if at the time of application, the owner does not have proof of insurance on 17, certificate of compliance may be issued only. If we strike, if at the time of the application, the owner does not have proof of insurance, and it just read a certificate of compliance shall be issued only when with written acknowledgement by the owner of the requirement obligations of section 1450 .51 of the Code of Ordinances. I think that would clarify what your concern was. If you are mid-inspection, the landlord has already said document, signed said document.
Sure, I think the concern about taking that portion of the sentence beginning at line 16 out though is that the city would prefer the owner and the tenant to have insurance. And so that is kind of the preferred method. And so if you take that out, then it sort of weakens the earlier language contained in line 11 and 13. That you provide proof of that insurance. I can certainly take it back if you would like.
I mean,
Just a thought. I mean,
Yeah.
My concern is if I keep hearing this, we would rather have the owner get insurance or force the tenant. And it's kind of defeating the purpose because now the price is going to go up on the rent and it's not just going up $5. It's going to go up hundreds of dollars. And that is a concern for me when we have this whole mechanism, this purpose of this mechanism to make sure that folks are being protected. I guess I don't see if we made those minor changes, how that would affect the rest of it.
I can certainly take it back if you'd like.
I personally, I'm fine with the sentence as is. I personally didn't see that as something that would move or shape how someone would conduct their business by, I guess I just don't think that property owner or landlord would see it differently, if that makes sense. It does bring up that your comment brought up an additional question for me. Some landlords or property owners, regardless of the meat of what's in here, may decide that this is going to somehow increase their costs and may pass this along to the tenant in terms of how much they're charging them for rent, regardless of what our intent is. And I think that's a reality that we should acknowledge. Not all. I mean, there's certainly good landlords out there, but some may look at this and say, well, naturally, I would raise my rent X number of dollars per month. The other question I had, somewhat of a concern, because we're doing this and it's a way to protect residents, help tenants who may have, derelict landlords who aren't, keeping the building up to snuff. My question is a bit complicated and I'm trying to figure out how to word this. In most lease agreements, you will see some provisions, and I'm using the most basic terms here. For instance, if there is damage caused to the property that is by the tenant, then the provision says that the tenant should fix, a clogged drain or a fixture that, they happened to knock down, and therefore it would be their responsibility to fix that per the terms of their lease agreement. If let's say there's an instance of an apartment building and someone is smoking a cigarette on their balcony and that causes a fire. Now we understand that there's fire damage. The landlord or property owner should relocate tenants to an alternate safe space, and then they would either have that insurance or have to pay the $85 per day that we'll talk about here shortly. Could you see a world in which, because the tenant could be liable for that damage, that the cost somehow from the property owner or landlord would go back to the tenant. Because of the terms of their lease agreement and having gone through this whole, this process, is there a world in which that could happen?
Potentially, I mean, that would be sort of a private legal dispute between the landlord and the tenant as to who caused the damage such that this property needed to be red tagged and therefore these expenses were incurred. We purposefully did not include kind of language in the ordinance that would require the city to figure out and identify who caused the damage. Because at the end of the day, when these things happen at 10 o'clock at night, or, the most pressing issue is to get people into safe and secure housing. And then in terms of figuring out the costs, whether it be the landlord or the tenant, would be sort of a private,
A separate
potentially
matter.
dispute between the two of them separate from the city.
I think Chairperson Pelivanoglou, in the instance of extreme things like fire, the Red Cross steps in. So, I think that example is a great example, but, that was something that certainly was on my mind is, if the damage is caused by the tenant, which, in the conversations I've had with Greg about this, this would not cover if the tenant were to make damage or, turn the stove on and burn the place down or whatever it may be. I think the spirit of this is to say that the state of Michigan really needs to make changes to the rental laws. We are a landlord heavy state versus a renter protection state. And they very much limit us to what we can do to protect folks. And I think this is one of the things that we really channeled down at least 8 months with Greg on this to get the proper wording. I mean, it literally came to a phone call, like thinking about a phrase and finding a phrase. And that's how, just be clear, that's how this was all born, was a phrase. And so I think that, the spirit of this is to just give us a little bit of protection, because realistically, and I know that each one of you have met folks where they're, sorry, you're gonna have to go pound sand. We can't help you. We know the landlord is bad. The sewage has been in your basement for 3 weeks and they refuse to fix it. This gives them an out where they can come forward and they can say, because I don't want to take calls anymore from folks that live in my ward and they tell me there's sewage in their basement. It's been there for weeks and they got kids in the house, but they got nowhere to go. So they don't want code to get involved.
Right.
Sure.
And that is frustrating as hell.
Yeah. And thank you for that context and thank you for that answer. I'm just trying to look at all angles and ensure that someone would not be able to take advantage of this with a contract such as a lease and be able to find some sort of loophole and then, ultimately disenfranchise that tenant. But it sounds like those discussions have been had and that would be highly unlikely. Okay. I have no further questions. Any other questions or comments?
I don't either.
Okay.
So if we were to move this, the public hearing would be what,
June
June?
23rd.
Okay. Do we have a motion?
I would move the resolution.
Okay. All those in favor say aye.
Aye.
All right. Motion passes.
23rd.
And if we could have a motion to untable item 5C.
So moved.
All right. All those in favor say aye.
Aye.
Okay, the resolution for introduction and to set the public hearing to amend chapter 1460, adding new section 1460.51 to create a tenant relocation fee and renumbering the existing section 1460.51. Lisa, would you like to go over this proposed resolution as well?
Sure, absolutely. So the big difference that you've seen previous draft 3 into what's in front of you right now, draft 4, is contained on page 2 of the ordinance, wherein it talks about beginning at line 14, the tenant relocation fee. your previous draft had the dollar amount being $85 per day in the ordinance.
Correct.
We have made the requested adjustment that it indicate that the amount per day is set by resolution of council. For your awareness, item D on your agenda is that resolution that sets the amount at $85 per day. Obviously, we would recommend holding on to that resolution at this point and passing it at the same time that you pass this ordinance, here, or that you have the discussion on this ordinance here in the next few weeks.
Any comments or questions from committee members?
No, when I read through this, I thought this captured our concerns. Perfect.
Yes.
I agree. With that, do we have a motion?
Yep. I would move the resolution to set a public hearing for June 23rd.
All right, all those in favor say aye.
Aye.
Okay, motion passes. Next, we're on to item 5D, a discussion of resolution establishing tenant relocation fees.
I think this is pretty boilerplate.
Right. that's
Yeah,
certainly-
just remind me in case we get questions, how we came up with 85 a day.
My understanding that is the city's, through the HRCS department's contractual amount that they receive, or that
Okay.
they are able to book rooms
Got it.
day at that same amount. So the goal is that we are only spending, what the city would usually spend on hoteling, and that we recoup those actual costs. We don't want to recoup anything above and
Yeah,
beyond.
that language
Yeah.
is very clear. Yeah. Okay. All right, perfect. Just discussion.
All right. Any other questions, just to be sure?
Your next meeting is June 24th, ironically, the next day after the hearing. So this will be on that agenda as well when the
Perfect.
ordinances get referred back to committee.
Okay, moving on to item 5E. Remind me if this,
It was tabled also.
it was tabled. Motion to untable. All those in favor say aye.
Aye.
All right, resolution introduction and set public hearing to amend chapter 1460, section 1460.50 to update and correct internal references.
Just one.
Right,
Yes.
right. Yeah, this is fairly straightforward. It changes the numbering, and I do see some language that's added on line 10 of page 2. If the IPMC is adopted in section 1460.01 of this chapter, but any questions, comments? Okay.
IPMC is International Property Maintenance Code, in case people aren't familiar with our lingo.
Acronyms.
Yes.
Living in a world of acronyms, exactly. Do you have a motion to introduce and set the public hearing?
I would move this for a public hearing on, is this the 23rd as well? June 23rd.
All right, all those in favor say aye.
Aye.
Motion passes. Any other business? I have nothing else for the agenda, and we are adjourned at 4:28 PM. Thank you.